When federal regulations are published in the Federal Register and the Code of Federal Regulations, ordinarily a citizen and anyone subject to them can find out what it is that's required of them just by reading that law. But the statutes permit an agency to refer to a standard that's been produced by a private standards organization like the American National Standards Institute simply by citation, and to incorporate that standard, which may be dozens of pages long, by reference. And then what the citizen knows if she goes to the CFR or the Federal Register is that this American National Standards Institute standard has been made a part of the regulation and therefore is, in this way of doing things, a part of her legal obligation. You could also imagine an incorporation by reference that didn't involve legal obligation. So an agency might say to people who have an independent idea of what the law requires of them, one way that you can meet the requirements of our regulation is by conforming to American National Standard Institute, thus and such. And in that case, the standard would not have the force of a legal obligation. It would be a kind of guidance that would permit the regulated party, and for that matter the citizen, to know one way of complying with the regulation. But the regulation's obligations would be themselves stated in the CFR or the Federal Register. And the difference between the two of these is that one is, in effect, secret law, and the other is not. In the first case, if it's a regulatory obligation which you must comply with, you can only find out about it by going to the American National Standards Institute and doing whatever they require to acquire a copy of the standard on whatever terms they're prepared to give it to you.